South Asia Committee of the International Law Section presents the Global Lawyers Summit in association with CNBC TV 18.
The South Asia Committee of the International Law Section, in association with CNBC TV 18, hosted the Global Lawyers Summit that witnessed the convening of diverse stakeholders who delved into a spectrum of legal topics. A key discussion themed Enhancing Efficiency, India's Insolvency and Bankruptcy Code, was inaugurated with a special address by Justice Amit Bansal, judge at the Delhi High Court.
In the years prior to the enactment of the code, India was beset with what is commonly referred to as the twin balance sheet problem. The twin balance sheet problem refers to a scenario where banks are under severe stress due to many NPAs and corporates are over-leveraged to the extent that they cannot repay their loans. The philosophy of the code is that comprehensive resolution of the distressed firm is better than the piecemeal liquidation of the corporate debtor. The code, to accomplish this objective, which departs from previous legislation of the same nature in several ways, two of which I would like to briefly mention. The first is creditor in control. After a firm is adjudged insolvent, the company's previous management is dislodged. In their place, a resolution professional, or RP, is appointed, and all managerial power of the company vests with them. The second notable aspect is the stringent timelines. The entire insolvency process from admission to approval of a resolution plan is supposed to conclude within 330 days, failing which the firm is to be liquidated.
Abhilash, whilst not wanting to give away your age, we believe that you got your license to practice in the year 2017. And within this 7 years, I'm sure you have not only had the ringside view, rather you were in a ring to test the effectiveness and efficiency of Insolvency and Bankruptcy Code. So my first question is, could you tell us what according to you has been the most effective in Insolvency and Bankruptcy Code? And at the same time, what has been the biggest constraint?
I think the IBC is a fabulous piece of legislation. Extremely well thought out, extremely well reasoned, and very effective if, and it's a very big if, the management experts say it's more important to do things right than to do the right things. The right thing somebody else will take care of. But Drucker famously said that you have to do it right. Execution is an issue. And I think all the best interests, the best intent of the IBC, unfortunately, are diluted because of the problems with execution.
Coming to Mr. Nair. Mr. Nair, what is your view on the effectiveness and efficiency of the insolvency and bankruptcy?
Our ranking in the global insolvency resolution improved drastically, moving from 136 to 52 within the first 3 years of the IBC's implementation. So this is the effectiveness which makes it a watershed legislation. The problems, I'll again come back. For me, the problem is essentially the weight of numbers. The legislature in its wisdom has sought it fit to include home buyers. I can tell you from personal experience, every bench on an average of the NCLT is hearing 40 to 80 matters every day. I don't think that's how the legislature intended this statute to play out. At least 50% are matters which are relating to home buyers. Each item that is listed before a bench has, on an average, 10 to 20, 30 interim applications, interlocutory applications. And in home buyer matters, these applications even go to 40, 60, 80. The legislature intended that there will be an authorized representative of home buyer associations. We are now increasingly seeing a situation where there are multiple home buyer associations. So those are the kind of difficulties that are being faced by benches. And I think that's taking away from the effectiveness.
Deepak, coming to you. What are your views on when we talk about effectiveness and efficiency of insolvency and bankruptcy?
For getting into effectiveness of any law, we need to just step back before it was actually enacted, before IBC. So as a lender before IBC, what was our numbers of recovery? What was the years typically we used to take? So in a company when it's under financial stress, unfortunately you have customers, vendors, lenders, and then equity guys. They didn't have one panel to go to. They have different courts, different, and they will be basically taking their case to individual courts. All the courts will not know exactly what is happening in that company overall. So there was no macro view. And that really, as a percentage, it was typically 26 cents to $1 recovery over a span of 5 years. So that was the average before IBC came. After IBC, now there is only one tribunal which go to, and all these guys go to one guy. And the RP is there. He will have a macro view, what is the issue in the company as a whole, and that he is going to solve it. So post IBC, the number is simple, 71 cents, and an average is 1.5 years to 2 years. This is the number of 2021.
Bijoy, coming back to you, how do you see and how do you manage that as well? I mean, other than your 2 cents on, efficiency and effectiveness of the IBC, how as a in-house counsel, how as a, operational creditor, you see this code panning around?
Yeah, it is in fact for companies like us which intend to thrive and expand, it's a very, very big threat for us if there is a threat of an insolvency proceeding, right? So whenever we are under that situation where we think that we probably might be dragged to NCLT for any such case, the endeavor is always to settle it, right? Because we don't want to, because there are a lot of stakes involved for companies. So there's, first of all, the goodwill is at stake. Secondly, they're investors and they're bankers. So it raises a red flag, and which is not taken very lightly by the management. It's a very, very big deal for companies, right? So in such scenario, we try and we ensure that the internal teams are aligned on making timely payments. We honor the payment terms. But however, there are scenarios where, maybe the service provider is not complying with the terms of the agreement, or maybe there's some shortfall in the services. In such scenarios, we ensure that the business teams are made aware that we need to put across the communications well to the service provider. And where need comes, we also send across legal notices just to ensure that these issues are highlighted, escalated before we are, at a legal battle before an NCLT.
Sir, we would like to have your concluding remark on this.
I think we have to be satisfied that some great results have been achieved, and it's a watershed legislation. For the first time, some procedure has been put in place. It's only been in place for 7-8 years. So in fairness, we must give some more time for it to iron out its various deficiencies.
South Asia Committee of the International Law Section presents the Global Lawyers Summit in association with CNBC TV 18.
The Global Lawyers Summit provided a dynamic platform for exchange of ideas and unparalleled networking opportunities for the legal fraternity. An enriching panel discussion deep dived into the topic of arbitrator's dilemma, balancing dignified exit and jurisdictional challenges. It commenced with a keynote address by Justice Mini Pushkarna, judge at the Delhi High Court, setting the stage for an insightful conversation led by a panel of esteemed experts.
At the heart of the arbitrator's dilemma lies the pursuit of a dignified exit which acknowledges the importance of persevering relationships, maintaining confidentiality, and safeguarding the reputation of the arbitration process itself. This imperative calls upon the arbitrators to foster an environment of trust, respect, and cooperation amongst the disputing parties. The legal community has always taken the inspiration from theoretical doctrines by legal jurists, one such being the doctrine of competence, which has taken a wide range of popularity in the area of arbitration, as it upholds the party autonomy and confers the power to the arbitral tribunal to determine on its own jurisdiction by setting the boundaries in regard to the interference of the courts in the arbitration process.
Let me start off with the role of disclosures. Why is it important in the arbitration process, and maybe some experiences on what the panelists have seen on how a disclosure has maybe changed the process of a dispute that they were in. Rajshekar, if I could start with you.
Thank you, Pranav. I think the answer is in that first question. Like you said, we have the whole purpose of arbitration is to be a substitute for a formal adjudicatory process. And the edifice of this entire structure rests on integrity. Now, integrity is not about how I perceive. I usually use this line so that old adage of I think, therefore I am. from an arbitrator's perspective, they think, therefore you are. It's because parties believe that you are somebody that they can vest their troubles in, and you will therefore give them a fair opportunity, is really what the foundational basis is. So I think the statute has been amended. It's ironical that we have to amend things to say that these are obvious aspects, but it's important to be reminded. So from that perspective, why disclosure? Because that is the foundational basis of the entire process. Should you disclose? The answer is yes. If in doubt, err on the side of disclosure. Now, what does disclosure mean? Disclosure means that as an arbitrator, I believe that these are facts that I need to place on the table so that all of you who have placed your dispute before me are satisfied that I don't have any predilections. That you're satisfied that I've made a clean breast of where I stand, qua the dispute, qua the parties, and as the statute says, any other kind of association.
Neelima, your views on this?
I think Raj has covered most of the territory for us. I may not have to speak so much now. Really, I divide the whole arbitration process into 4 steps, where I see that there is a need for, the parties, the litigant particularly, to know as to what his or her rights are. The first stage is the disclosure stage. The second stage is the proceedings, where the requirement of the due process and other requirements as per the Act arise. The third stage is the award and the scrutiny of the award, which is unfortunately completely absent in India because there is no institutional arbitration. If there was institutional arbitration, then most institutions normally provide for a scrutiny of the award itself. And then, of course, the award itself and the 34 rights, whatever are the grounds for challenge.
Mayani, do you have any views on disclosure?
In practice, we used to have this unsaid sort of practice that if there was a non-disclosure and a subsequent challenge, the subsequent challenge would always be evaluated considering that non-disclosure as an aggravating circumstance. And the reason for that is that over a period of time, the independence and impartiality, or the lack of it, reflects in the manner that the proceedings are conducted. So you have, procedural irregularities coming along the way. You have decisions which show sort of a non-application of mine in procedural, in procedural orders. And so when you have then the discovery of a circumstance which could have been known before to the parties, and they could have had the opportunity to correct the course of the arbitration right in the beginning, and that is not given to the parties as a benefit that they could have exercised, you consider that as a circumstance that justifies the removal of the arbitrator and therefore a successful challenge.
Ma'am, would you have any comments on disclosures and how they add to the legitimacy of the arbitration process?
Yes. See, arbitration is seen as a process which is by consent of the parties. And it is seen as an alternate dispute to the actual courts who are dealing with the adjudicating the disputes between the parties. So therefore, it is imperative that an arbitrator discloses all what is material in terms of the act which could raise doubts with respect to the impartiality or the or independence of the arbitrator. And it's very clear that as far as arbitration process is concerned, the independence and impartiality of the arbitrator is the main foundation of arbitration. Because if that was not so, then where is the question of having any alternate dispute resolution process? Because impartiality is the main foundation. And this disclosure has to be not made only at the commencement, but in case during the proceedings, the arbitration proceedings, if there are some circumstances or situations that arise which the arbitrator feels that should be disclosed to the parties, the arbitrator should certainly disclose that and not keep to himself or herself.
The summit was also graced by the Chief Justice of India, Dr. Justice D.Y. Chandrachud, who delivered the valedictory remarks.
I must congratulate Pratibha and her whole team for their industry in organizing this event, which brings together a diverse array of minds. I'm sure it was not easy to organize conversations around almost 25 different sessions, which were just as diverse and relevant. I believe that passion-driven conversations are melting pots of ideas. They provide a direction to meaningful policy initiatives and actual change at the grassroots. Interdisciplinary conversations transcending the realms of law, policy, regulation, business, and governance are tremendous learning resources for the change makers of today, and more importantly, for the future. Philanthropy is considered contrary to distributive justice. Why? It's contrary to distributive justice, or considered to be contrary to distributive justice, as it creates a certain social hierarchy and does so in an arbitrary manner. It is an unreliable medium of change because it is subject to individual motivations and charitable impulses because of its non-institutional, uncoordinated character. So much as we speak about the importance of philanthropy within our own profession, it's important for us to understand the flip side and to overcome the flip side by seeking to institutionalize what otherwise becomes really ad hoc individual initiatives. John Stuart Mill years ago argued that lasting relief should be the responsibility of the state, and that charity almost always does too much or too little. And he said it lavishes its bounty in one place and leaves people to starve in another. This critique, I believe, subsides when we speak of philanthropy in the form of agency-enabling services, such as legal assistance, or what Justice Sikri said yesterday as legal social responsibility. The law can foster the coordination of philanthropic endeavor. We see an example of this in the regulation of corporate social responsibility, as well as in the legal aid mechanisms in our country. The legal service institutions across the country, you would be surprised to note, now have over 31,128 experienced panel lawyers, 42,446 paralegal volunteers, and 7,968 pro bono lawyers across the country. Having a dedicated team of lawyers ensures a steady and consistent availability of legal aid, rather than a case-to-case basis search for legal assistance. But the real problem which we face is not in terms of numbers, but in terms of quality. And how do we bridge this gap between numbers, between the demand and supply, between volume and quality legal services? And I believe the answer lies in creating a platform for opportunity, particularly platforms for opportunity for those who have not been mainstreamed in the past.
Marked by multiple panel discussions, insightful dialogues, and the presence of diverse stakeholders from the legal community, the two-day summit concluded with a vote of thanks by Pratibha Jain, Chair of the India Committee at ABA and Head of Strategy and General Counsel at Everstone Group, who extended her appreciation to the esteemed speakers, delegates, and partners for their valuable contributions.
Honorable Dr. Justice D.Y. Chandrachud, the Chief Justice of India, Ms. Nilima Tripathi, Senior Advocate, Supreme Court of India, Ms. Pallavi Shroff, Managing Partner, Shardul Amarchand Mangaldas, and Ms. Vinita Sinha, Assistant General Counsel, Asia IFC, Justice Jasmeet Singh, Justice Amit Bansal. Ladies and gentlemen, it is with immense gratitude and admiration that I thank Dr. Justice Chandrachud for accepting our invitation today, sir. It's almost when you were speaking, I was thinking, we are all converging towards what I think from the legal profession's perspective is the need of the hour. One of the other initiatives other than the Pro Bono Club of Lawyers we've promoted in this conference is the We for Her Foundation, sir. we have reached the end of this conference. It's been a mammoth task, and it would not have been possible without the help of many. But foremost amongst them are the partners for this organization. I'll quickly name them because this was absolutely not possible without their support. AZBN partners, Cyril Amarchand Mangaldas, JSA Advocates, Khaitan & Co, K-Law, Nishid Desai Associates, Sarafin Partners, Shardul Amarchand Mangaldas, Trilegal, SNR, APN Partners, Goodwin, KNL Gates, Osborne Partners, Sidley, Singhania & Partners, Cadden, Veritas Legal. Some of these foreign law firms are not even here. They weren't able to send anybody to the conference but supported the conference. I also want to thank our knowledge partner, OP Jindal Global University, CSR partner, V for Her, Federation of Corporate Lawyers, iPro Bono, IVCA, the Indian Venture Capital Association, SIAC, Singapore International Arbitration Center, and US-India Strategic Partnership Forum.
South Asia Committee of the International Law Section presents the Global Lawyers Summit in association with CNBC TV 18.